Now the Auditor-General has said, I'm sure you would like to hear what the MACC has to say. So inevitably, we are party very close to the audit report. Now, when we talk about the audit report, every year when the audit report comes out, actually, MACC is always very enthusiastic. It's very enthusiastic because we also like to know what's going on. But enthusiastic is one thing, but we have to be practical. Now, what is normally in the Auditor-General report? Now, this is what is normally in an Auditor-General report. Discrepancy in the use of funds, questionable purchase, supply of goods, not according to specification, wastages, leakages, misuse of power, abuse, negligence, misdemeanors, lack of supervision, monitoring, non-compliance to financial regulation, delayed implementation, cost overruns, double payments. See, there are hosts of things in the audit report. But, you see, another interesting part, of course, is the misuse of power abuse. You see, that tends to attract a lot of public attention. But we have to view all this in its proper perspective. What is corruption from the criminal law perspective? Now, this is a normal definition for corruption, abuse of entrusted power for private profit. This is by Transparency International. But for in the case of MACC, what we want to know is corruption from the perspective of criminal law, which is in our Act, it doesn't define corruption, but it spells out instances which human action are being criminalized for corruption, such as abuse of position, pose for gratification, the use of documents containing false material particulars, active bribery, passive bribery. Okay, all this is very academic, right? But let us go to the basics. What is a crime? A crime is basically an act that is defined by statute or ordinance as a crime. Specific condition. The elements of a crime must occur for a crime to be called a specific kind of crime. Key elements are menstrual and active reckless. Okay. Now, what happened is, of course, now in the Anti-Corruption Act, there's a provision that says, MACC, if they have reason to suspect the commission of, if a report has reason to suspect the commission of offence, following a report launch, or information received, we have to pause the investigation and use all powers of investigation. The question is, there must be very strong suspicion of the commission of offence for us to commence an investigation. Now, what are the actual offences in the MACC Act? It is to accept or to give a gratification. It includes elements of solicitation, attempt to obtain, inducement, reward, okay, to any person to influence his conduct. It involves cases, offences of using false claims. Okay, that means inter-parties documents, abuse of power or position for gratification. Now, for a layman understanding of this, anything he read in audit report, he will say this is corruption. But ladies and gentlemen, things are not that simple. In fact, we will hope that it is so simple. A case of corruption, for instance, it involves two parties. It involves generally mutual benefits. It's a profitable win-win situation. It's something confidential in private and in secret. It involves giver, receiver, middleman. Suspecting it is one thing, but proving the offence, that is always a major hurdle. Now the key problem here is we need to show that it's gratification, there's something paid, something valuable, paid or received. Okay, with the exception of false claims, you need oral testimony, you need documentary evidence. And this thing will not land on your desktop. you have to go and search for it. Now, for instance, when you say, when you charge someone for corruption, it will be in respect of obtaining a bribe for specific favor. You have to show that the bribe was paid. Whether even, and this has to come from certain witnesses. You have to show that the bribe was in relation to a contract. This again has to come from someone. Now, you must understand that when you talk about bribe payment, payment of bribery, it always involves, people who are givers, who are accomplices, businessmen. You question them, they will tell you, we hear nothing, see nothing, know nothing. So you cannot possibly, it's quite difficult for you to get someone who volunteers unless he is an aggrieved party. He's a aggrieved party, there's a fallout. And then he comes to you and tell you, I have made certain payment. Again, after obtaining such evidence, then there's a question of he being accomplice. You may not succeed in court. Of course, we can try to prove the offense of corruption, and in terms of investigation approaches, there can be two ways. One from the point of receipt of the payment, and one for the point of payment. From the point of payment, if it's on books records, of course we can trace it. On the point of receipt, if it's off book records, of course we try to trace it from the point of receipt, by checking through bank accounts, paper trail, tracing the money. But of course, in the real life, things are not so simple. Nowadays, people know how to hide, how to launder. See? Now, even in a case of an offense, of using a document, which contains false material particulars, it's a very technical kind of offense, in the sense that one, the document used must be an inter-parties document. What I mean by inter-party document can be like this. Now, your punch card, you punch your card, okay? Then you didn't come to work, you get someone to punch, so that you can say that document is false. False material particulars, whether that person is liable for corruption. But under the law, it's not so simple. That document must be an inter-party document in the sense that it must be used for certain purposes, and it is not a document purely maintained for the purpose of accounting or internal purposes. See, to become a document of substantive value document in the sense that, let's say he make a false claim that for work purpose he submit a claim, then the punch card is attached to the claim, then it can become a case. In that sense, that is why in offences where it involves the use of a false document, first a document must be used. The government is interested in the document. The person submitted it must have reason to believe it's false. Using it is one thing, he must have reason to believe it's false, and the person submitting it intended to mislead the government. Now, we have offences, a lot of offences, for instance, end of the year purchases by government. End of the year, the government access money, then if you do not spend the money, the government practice is that it's considered burn. So what happened is, procurement officers, they buy things, but sometimes the things the contractor is not able to deliver the items. Okay, so but he will make a certification the items have been received on understanding that the goods are to be arrived in the future. Technically, it's an offence under the case of submission of a false document intended to mislead the principals. But of course, when we talk about prosecution, there's always two stages. One is of course the evidential stage, and then one is of course the public interest stage. So a lot of factors is taken into account. Of course, it's not my right to talk about prosecution because I'm not from the public prosecutor office. Now, typical examples of cases involving a false claim would be when you certify a claim for a course which is not conducted, you certify a cost for repair of office equipment, you certify receipt of goods which is not according to specification when it's not. A false medical certificate, for instance, you use a false medical certificate to obtain leave. A false mileage claim, false invoice delivery order. These are the kind of offences that we are interested in. The other offences is when we talk about using a public office or position for gratification. Now, when audit report says, there's a misuse of power, misuse of position, the public is of course quick to jump. There's corruption. The MACC must investigate. They must charge somebody. But this specific offence of the law is very technical. I give you an example. Let's say you have a public officer. He is provided with an official car. Okay. Now he maintains 2 homes. One in maybe in Klang, one in Subang. Okay. He got 2 homes lah. Let's say his first wife is with Klang, second wife is in Subang, and then his office is in KL. What happens is every morning, he take a short diversion. On the way to Klang, he can use the highway, but he diverted to Subang, had a short stint with the wife, then he goes to work. So the public will say, hey, there's gratification, is what it means. Sex with the wife is not gratification, it's gratification under the law. But that is not the kind of offences that the law had in mind. It's of course sometimes MACC themselves jump into the foray, by saying this is wrong. So the public also perceive this is corruption. It is corruption, I agree, but it is not corruption in the legal sense, in the criminal prospective sense, in the sense that you can charge for this kind of offences. The most likely is that you go after him for disciplinary action. But the moment when we say it's corruption, then the public tends to equip the moral corruption with the criminal perspective of corruption. So when the public see this kind of cases, they also expect somebody should be charged for offence. Okay. Now, I just want to let you know. Now, detailed examination and due investigations were instituted following complaints on corruption, abuse of power, and malpractice stated in the Auditor-General 2011 report presented on Parliament on October 15. This also includes inspection on system and procedures that could be vulnerable to corruption. 3 individuals were charged for that 2011 year audit report. This was in respect of the supply of the SR digital camera for the Royal Customs Department. The company owner and the custom officer was charged. This case involving the purchase of a digital camera. There were 14 units purchased, each unit costing 9,000, but what they purchased was a different model, a Sony camera costing less. That is, the actual price was 360,000, but they purchased at 240,000. Okay. The other case was this was a principal of one of the boarding school in Johor, Pontian, where he faced 14 charges for misuse of position for gratification, in the sense that he issued 14 payments vouchers, 14 Maybank Islamic checks with a total combined value of 1.1 million to Zainab Enterprise, a company that was owned by his wife. The payment was for catering of meals for the school hostel. The third case was, of course, a technician from the Pejabat SUK Negeri Kedah was charged for an offence of submission of false claim valued at 11,800 in respect of maintenance of flats when the job was done, when it was not done. Now, in the audit report 2012, recently, there was a bekas penghulu and other people that were charged together with him for a total of 52 offences, for forgery. They make a false application to get the subsidy of paddy in the name of 52 applicants who were not who did not actually apply for the subsidy of the paddy, subsidy of the fertilizer. What happens was he put his own time print, on the application form to get the fertilizer. Now, now having said all that, now I was involved in the audit investigation, and I can seriously tell you, this the MACC actually we take a very great interest in the audit report. In the year 2012, for instance, in the year 2013, we had a special task force, and this was the practice since then. We would have a special task force where we practically employ easily half the personnel of our investigation division to look for cases in the audit report, give our full focus and time to investigate cases which we suspect there were elements of corruption. Of course, we work closely with the audit department. This is a work that is done on a full-time basis, very intensive. This is it was a special task force set up by the Auditor-General himself, and we work under the guidance of the public prosecutors, and they are very thorough. That even our officers feel, are we going for civil proceedings? The way we are investigating, like we are going. No, is there any breach of other civil, not only criminal? No, the way the public prosecutors guide us, as if they want to sue somebody. So it's something very new for our officers. Of course, if you look at the number of cases, for instance, in the year 201, I can't recall because no longer in investigation. In the year 2012, for instance, we opened up 2011, we opened up 26 investigation papers, out of which only 3 papers ended up charged. In the year 2012, we opened up 20 papers, only 1 paper ended up charged, and that was, and then of course there are 1 or 2 papers still, the result is still pending. Now, if you look at this kind of statistics, if we were a business organization, we shall close shop, right? We shall close shop, because the outcome doesn't commensurate with what we do. But I must correct myself again. Please remember, we are a law enforcement agency. Our duty is to find out what happened on the basis of evidence, determine whether there is a case, and then decides whether recommendations should be made for the prosecutors that the case be brought to court. Sentiment is sentiment. See, officers who do involved in audit investigation, I do not disturb. We do not. You don't dispute their professionalism. But of course, as human, you feel there must be something wrong with the case. They work very hard. But if the outcome is different, it's never due to the lack of effort. Besides this, I'd like to stress that although the number of cases that we charge is quite limited in relation to the audit report, like I said, because a lot of offences, they don't come between the ambit of the law. They do not come between the ambit or the parameters of the Anti-Corruption Act. See, we would love it if it could have come, but it is not so. So a lot of cases will have ended up maybe about 5 or 6 cases every year. Maybe about, let's say 30% of the cases that we investigated will end up with some kind of a disciplinary action. Then there will be a recommendation for the improvement of the system and procedures of government department. Now, although I work with MACC, see, I don't represent the government, but I have to say that the government, especially the Chief Secretary of the government today, he has taken a very serious view of the audit report. Why do I say that? In the year 2012, what happened was the government set up a special investigation team, you know. This is besides the MACC, you know. What MACC is doing, you know. And I remember Tan Sri AG called for that meeting. A special investigation team was set up to look into various aspects of the audit report. And the Public Service Department was responsible to appoint, especially those that were non-criminal in nature. In fact, all that were non-criminal in nature, the Public Service Department will identify teams to do the investigation. And do you know who head this kind of team? The process will work like this, you know. Let's say if you are from the Works Ministry and there is something reported in the audit report that is not proper as regards to performance there, another officer from the Health Ministry will be heading this investigation team. And this officer is a minimum of super scale JUSA C above. A very, very senior officer from another ministry. He also has among his team members of the audit, officers from other departments that is identified by the Public Service Department. So another department will be investigating the offences which are for non-criminal in nature, purely for the purpose of identifying whether there is any breach of government procedures, or if there is any criminal offences detected, to refer the case to the police or the MACC. Now, I will say this is a very high level of commitment, because I remember in the year 2012, there were about 15 teams set up, you know, and these teams, you know, they have to give subsequent feedback, you know, to the Public Service Department. If let's say they recommend certain action to be taken, and the department did not follow up, the matter will be reverted to the Public Service Department to follow up again on the matter, and it was a monthly kind of meeting. So you can see what is the resultant effect of this kind of approach. To me, this is something very drastic, draconian, in the sense that now, if you are a Secretary General, you know, or you are the senior officer in the Health Ministry, you are asked to investigate something in another ministry. I'm sure when you go back, you know, you gain a lot of knowledge. You gain a lot of insight, you know, into what's happening. And of course, you do not want the same thing to be happen to your own department, because you do not want your own department to be investigated. So you are likely to do a lot of internal control, comes up with recommendation, work towards ensuring that your own department do not become a subject of investigation by another department. Because this is really from the top down, you know. You know, you are getting the people in the top, and you will find that a lot of these officers who form this investigation team, although they find the task very difficult, involve a lot of hard work, they will all admit, you know, that they learn a lot from these experiences. I believe this is something that is it will be very fruitful in the long run. The other thing is, of course, the other approach that was taken by the Chief Secretary of the Government, of course, you know, is is to have the head of departments themselves, you know, to meet up with the media, to follow up on the audit report, so that the head of department can explain what exactly happened. This again is something, it's a vast improvement, because it will create a culture of fear for everyone. You know, if you are the head of the department, would you like to face the media, face the press? Would you like to face C4 to explain what's going on? So I believe this is a very is a measure which acts as a deterrent. Of course, anything that is, of course, although the audit has uncovered a lot of, you know, abuses, malpractices, this will definitely take time. I'm reminded of what happened to a colleague of mine. He was telling me this story. You know, he has a son who is a doctor. So every time that the son comes back to his house for holidays, you know, and the son always has this practice. You know, when he cleans the dishes, he just dump everything in the sink and let it clear by itself. So the sink gets stuck. What the father do? The father would clear the sink and tell him, "Come, don't do this. You know, you jam up the sink, have to clean it up, that kind of thing. Okay? Well and good. Next holiday, he come back, he repeats the same thing. I mean, he doesn't clear the leftover food, but he dump it in the sink, and then the sink gets jammed up again. That is the next visit he comes back. And you are talking, you know, he's a doctor, and he cannot even be compliant. I do not know whether this is a new generation or it's not fair for me to pass judgment, but that is probably what is happening in our society. You know, people are less disciplined nowadays. Okay. Okay. Another issue is, of course, like I said, you know, MACC does a lot of investigation work on suspicion of corruption, but sometimes we do not make any headway due to the technicalities in the law. That is why when Tan Sri Ambrin say that this problem is likely to occur, I think I would tend to agree with him. So, unless unless we have very drastic laws in the sense that we make people liable. How? The MACC is, of course, trying to look into an area of law which is we feel is very relevant. It's a case of misconduct in public office. The mechanics of this law is like this. If you have a public officer or public servant who, in the course or in relation to his public office, okay, willfully misconduct himself in the sense that he does an act or he omits to do an act without reasonable excuse or justification, the misconduct was serious, having regard to his office and the office bearer, where it amounts to an abuse of public trust, you can be charged for an offence of public misconduct. For instance, a government servant who does a purchase without doing proper market study, okay, without proper market study, in contravention of procedures, knowing that the government said he must do a market study, he doesn't do it. So what happened? You charge him for public misconduct. If he can show that there was no excuse, no justification, he did it deliberately, recklessly, he knew his conduct was unlawful, it was against public interest, this would be a very effective deterrent, because an offence of public misconduct can be applied for various conduct, action, non-action, where the act amounts to an abuse of public trust. We do not have to prove that actually he made a cut, or he made money out of the offence. But if he can show that this offence brings about an advantage to some other person, a contractor benefits, you know, someone else benefit because of his misconduct, then you charge him. So this is what we are trying to have as a law, to codify it. It's a common law offences, but they're trying to codify it. I believe if we can have this law, we can address a lot of offences that is committed by public servants. Thank you.